Hello wonderful people, welcome back to your wonderful channel where we bring you back-to-back update and information. Please go ahead and subscribe to our channel like I have always promised you that I'll be bringing you back-to-back information in Biafra land as the hot. This is the video of NNAMDI KANU'S court proceedings in the UK. The UK people are deciding on the issue that concerns NNAMDI KANU. I will be playing you the video. This is the one that my hand could reach now. I will also be updating you on every happening so that you'll be updated and know what is actually happening. Just pay attention and look at that court proceedings and what is just happening in the courts.
I appear for Mr. Kingsley Kanu, the appellant, together with Ms. Eatwell and Ms. Buchanan. And my learned friend Sir James, ED, King's Counsel, appears on behalf of the respondent, together with Mr. Birdling and Mr. Klimowitz. Just before I start, I think it is appropriate to do a little bit of housekeeping to check that you have all the bundles. You should have 2 hearing bundles. One is a core bundle, one is the supplementary bundle. And the supplementary bundle should end at page 527.
527, yes.
Great.
And is there a prize if it does end at 527?
I'm not sure who the prize would be for, but yes, I think there probably is. And then there should be the authorities bundle should have been supplemented with 2 additional authorities in the last couple of days, El Masri and Bel Haj.
Yes.
And with that, I think the housekeeping ends.
Good.
My Lord, before I begin my submissions, I should say that to begin with, at least, I'll be referring to the judgment below, and that begins at page 97 of the core.
Yes.
My Lords, the issue in this appeal is what obligations and the scope of the obligations which the respondent owes to British citizens who are detained by a foreign government abroad. As my Lords will have seen from the judgment below, the stakes could hardly be higher than they are in this case. 2 years ago, on 19th of June 2021, the appellant's brother, NNAMDI KANU, was the victim of an extraordinary rendition. Mr. Kanu is a British citizen and he was travelling on a British passport. He is also the leader of the indigenous people of Biafra. He was abducted while he was in Kenya by the Nigerian security forces, held incommunicado in a secret location and ill-treated over several days. Then, on around the 27th of 2021, without any access to due process or a court of law, he was forcibly removed across the border on a secret flight to Nigeria. Once there, he was detained and charged with criminal offences which carry the death penalty. My Lords, as the judge records, and this is paragraphs 4 to 5 of the judgment, these are not just allegations of ill treatment and extraordinary rendition. They are the findings of 2 Nigerian courts, including the Nigerian Court of Appeal. From the 13th of October 2022, that's the Court of Appeal, and the 26th of October 2022. And my Lords, I don't propose to go to those judgments, but I'm going to give you the references, which is what, that is what paragraphs 4 and 5 of the judgment below are drawn from. The 13th of October 2022 judgment is at Supplementary Bundle 298 to 386, and the 26th of October judgment is at Supplementary Bundle 212 to 251. Mr. Kanu has, in the 2 years since his extraordinary rendition, been in the custody of the Nigerian Department of State Services, which I will call DSS, where he is being held in long-term solitary confinement in conditions which threaten his precarious health. And that, my lords, is at paragraph 6 of the judgment. He is there and remains there, notwithstanding his success in the Nigerian Court of Appeal in October 22 in overturning the criminal charges against him. That should have led to his release. But the Nigerian government has appealed the dismissal of those criminal charges to the Supreme Court and has obtained a stay in the meantime. But it's important in my submission that the grounds of appeal do not on their face dispute the findings of extraordinary rendition. They argue instead that the court was wrong to find that that extraordinary rendition deprived the criminal court of jurisdiction to hear the criminal charges. And those grounds of appeal are in the supplementary bundle at pages 185 to 192. Just to give a flavour of the sorts of arguments that are being run in the Supreme Court, one of the grounds of appeal, which is at supplementary bundle 188, says that the essence of criminal jurisdiction arising from abduction of a person from a foreign jurisdiction has been, and I'm quoting this, male captus bene detentus, translated as wrongly captured or properly detained. So that is the basis on which the appeal has been mounted, that the criminal court retains jurisdiction, notwithstanding the findings of extraordinary rendition. Now that appeal still hasn't been heard, neither has Mr. Kanu's application for bail. It's currently listed for the 14th of September, having been adjourned from a prior hearing date of May 2023. And in the meantime, Mr. Kanu remains in solitary confinement in detention. Now, as the judge also recognises in his judgment at paragraph 3, the extraordinary rendition is not the first time that the Nigerian government have sought to harm Mr. Kanu. 4 years earlier, in September 2017, while on bail for criminal charges, Mr. Kanu was forced to flee Nigeria in fear of his life after the Nigerian military launched a violent raid on his house in which they attempted to kill him. And that attempt on his life is also a finding of the Nigerian court from January 2022. That judgment is at supplementary bundle 261 to 282. Now, together, all of this means that the Nigerian government planned and executed Mr. Kanu's abduction in June 2021 in circumstances where they must have known that his lawful extradition could never have been achieved because of the risk posed to his life. Now, in all these circumstances, the appellant, Mr. Kanu's brother, has since July 2021 sought urgent assistance from the respondent to obtain Mr. Kanu's release, to protect him from harm while in custody, and to seek accountability for his rendition and ill treatment. My lords, there's no dispute that the appellant has a legitimate expectation that the respondent will consider those requests. That expectation was identified in the Court of Appeal's judgment in Abassi, and I will come later to examine that judgment in detail. Nor is there a dispute that the respondent has considered the requests and taken a range of steps in consequence. And those steps are set out in the judgment below at paragraphs 9, 11, and 22 to 24. Thus, the respondent has intervened on Mr. Kanu's behalf, raising the allegations about his unlawful transfer, and his concerns about his ill treatment with the respondent's Nigerian counterparts on a series of occasions. He has sought responses to those allegations, and he has also sought reassurance about Mr. Kanu's conditions of detention. But the respondent has refused to go further, even though he accepts it is open to him to do so. He has not acknowledged publicly that Mr. Kanu is a victim of extraordinary rendition. He has not made representations to this effect to the Nigerian government privately, and he has not called for Mr. Kanu's release. He has also not taken steps to impose sanctions on anyone responsible. Now, my lords, he's explained the approach that he's taken in 3 disclosed ministerial submissions from the 6th of July 2021, the 6th of September 2021, and most recently on the 10th of August 2022. Those ministerial submissions, which I will come back to, are in the supplementary bundle at pages 130 to 144. He's also explained his approach in the evidence of Ms. Sarah Broughton, which is in the supplementary bundle at page 51. And again, I will come back to that. So what is the appellant's case in this appeal and the claim below? Although the appellant wishes that the respondent would take these steps, as the judge recognises, and you can see this from the judgment at paragraphs 17 and also paragraph 26, it is not his claim, and he does not seek by his claim to require the respondent to take those steps. It is the appellant's case instead that in order to take a properly considered decision as to what steps to take, the respondent must first reach a clear internal view as to whether Mr. Kanu has been the victim of an extraordinary rendition. The appellant says that clarity on this prior question is an essential component of a lawful decision-making process and essential to meet his and Mr. Kanu's legitimate expectation. But the respondent has instead, starting on the 30th of June 2021, the day after Mr. Kanu was charged in a Nigerian court, maintained only a provisional view as to the legality of Mr. Kanu's transfer and detention. And my lords, can I now ask you to turn up Ms. Broughton's statement in the supplementary bundle at page 68. So the statement begins at page 51. And at page 68 is paragraph 45B, which is part of a list of updates on new information that were given to ministers. And you'll see at B that on the 30th of June 2021, the respondent's officials updated Minister Duddridge, the Foreign Secretary, and Minister Adams, setting out the steps that were being taken in Mr. Kanu's case and containing an FCDO's officials' provisional view as to the likelihood that Mr. Kanu's transfer constituted extraordinary rendition and his arrest and detention violating international human rights laws, and as to the involvement of Kenya. And the same point is made at paragraph 47E on page 72. On the 8th of July, a briefing note was given to the respondent's officials who were meeting with the Nigerian foreign minister, containing, you'll see at the end of that, paragraph, subparagraph, an official's provisional view as to the legality of Mr. Kanu's transfer, detention, and the likelihood of trial. My lords, that provisional view, or that view that he has taken, has remained provisional or preliminary ever since. And it remains so to date, notwithstanding the developments in the evidence and the passage of time. And we can see that from the following letters and other documents. So the letter, the respondent's letter of the 14th of April 2022, which is under challenge, one of the decisions under challenge in these proceedings, is at 435 to 437 of the bundle. This is a letter that was written in response to a request on the 23rd of March 2022. You can see this from paragraph 1, a request from the appellant to acknowledge that Mr. Kanu had been subject to extraordinary rendition. And you can see at paragraph 3, the FCDO does not consider it would be appropriate to confirm unequivocally that Kenya or Nigeria's conduct was in breach of international law. Instead, the FCDO considers the appropriate response is to continue to raise the circumstances of Mr. Kanu's arrest with both governments. And similarly, in the letter of 9th of June 2022, this is a response to the pre-action protocol letter at 457 to 461. At paragraph 4, previous correspondence has set out the considerable diplomatic efforts which are being made, including at the highest levels, to provide Mr. Kanu with consular assistance and to make representations on his behalf. In deciding to take these steps, the Secretary of State has necessarily formed a provisional view on the information available to her as to whether the allegations are credible and as to whether they either do or may constitute a violation of international law. The Secretary of State is not prepared to share this view, and does not consider it appropriate to do so. And then again, at paragraph 17, the Secretary of State has considered what steps would most assist Mr. Kanu with regard to her provisional view, this is at page 459, as to the legality and gravity of Mr. Kanu's treatment, as well as the representations submitted by your client alongside advice from the FCDO. And in Ms. Broughton's witness statement, turning back to that in the supplementary bundle at 67, the supplementary bundle at 65, this statement you'll see at the end, which is at page 676, is dated the 4th of October 2022. You'll see, so at paragraph 39, when considering what further steps are necessary, the FCDO will often, as it has done in this case, reach a preliminary view as to the credibility of the allegations based on the material available. In conducting this assessment, the weight that is accorded to various pieces of evidence varies depending on the circumstances of the individual case. My Lord, rather than me read this out, could I ask you, because these paragraphs are going to be important, to read paragraphs 39 to 42?
Yes.
Or 43, in fact. So, my lords, you'll see that on the basis of that preliminary view, the decision has been taken as to whether to make a public statement, and that a number of other factors have also been taken into account. And then at 42, Ms. Broughton has explained that forming a concluded view in the face of evolving evidence would not be appropriate, and that reaching or publishing a concluded view would not change our objectives or how we've approached the case. And at 43, she cannot foresee what new evidence will come to light. And then if I could ask you at 44C, which is at 60, to look at 44C, you'll see that the submission that was made, the ministerial submission that was made on the 10th of August, considered the option of calling for Mr. KANU'S release. In the middle of that paragraph, the government's policy was that calls for release should be a last resort in exceptional circumstances. And at the end of that paragraph, the submission also contained provisional and legally privileged advice, so we can't see it, as to Mr. KANU'S allegations of arbitrary detention. So that was Ms. Broughton's position on the 4th of October 2022. My lords, it hasn't changed in the light of the judgments of the Nigerian Court of Appeal and High Court, and you can see that from the recent correspondence, which is an exchange at supplementary bundle 473 and 475. And at 473, you'll see a letter from the appellant's solicitors, Bindmans, asking towards the end of that letter, referring to a paragraph of Mr. Justice Swift's judgment, which stated, paragraph 29, no doubt the Secretary of State's approach will now also be informed by the conclusions set out in the judgments of the Court of Appeal of Nigeria, given on 13th of October, post-dating the evidence filed in these proceedings. I've seen reference in correspondence to a note verbal sent on the 24th of October 22, presumably sent in the light of those conclusions. And the letter at the bottom of the page says, last, please confirm that it remains the Secretary of State's position that the internal view on what has happened to Mr. KANU even now remains provisional because of the evolving evidence and the constant inflow of new information. It's referring back to Ms. Broughton's statement, which you've seen. And the reply comes at page 475,
Yes.
paragraph 3. The Nigerian government our client is aware of the decision. The Nigerian government is currently appealing the judgment of the appeal court to the Supreme Court. As such, the nature of this case continues to evolve, and our client will assure he remains apprised of any new information. That is the response to that question, and it must therefore continue to be the case that a provisional view has been taken. And indeed, that is the position recorded in the Secretary of State's skeleton argument a couple of weeks later, on the 30th of May 2023. You can see this in the core bundle.
Well, just before leaving, can I just invite you to cast an eye down the rest of that letter so you can see what action has been taken in the light of those developments?
Yes.
Thank you. Don't need the details, just to get the sense of it.
My lords, just since you have been asked to look at it, at 4A, you'll see that some further note verbals were sent to the Nigerian government, including one on the 19th of December 2022 and a further one on the 2nd of May 2023. It's at 475. And there was, for the first time, as we understand it, a response to one of those note verbals from the government of Nigeria. We haven't had any information from the respondent about what that response contained, and there's been no disclosure of either the note verbal or the requests. my lord, so the skeleton argument is at core bundle 57. Begins at 56, but at paragraph 2, you'll see how the respondent characterises the appellant's appeal as being Secretary of State is obliged in public law to intervene in a particular way by reaching an effective final view on the allegations. Secretary of State has declined to take that course. He has confirmed that he has considered those allegations and has formed a provisional view as to their credibility and on whether they may constitute a violation of international law, but has declined to share that view. So, my lords, the position remains that the Secretary of State's stance on whether Mr. Kanu has been the victim of an extraordinary rendition is provisional. And that means that all the decisions on what steps to take have been taken on this uncertain, provisional, or preliminary basis. And it is the appellant's case in this appeal that starting point is unlawful for 3 reasons. It's a breach of his legitimate expectation, that's ground 1, based on Abbasi, and the requirement that's set out there in a number of paragraphs 92, 99, and 99, and I'll come back to them, to at least start from a formulated view as to whether there has been a breach of rights and as to the gravity of the resulting denial of rights. That's ground 1. This is all in the appellant's skeleton argument, which starts at page 71 of the core bundle. Ground 2 is it's irrational due to the overwhelming evidence of extraordinary rendition and the fact that there is no prospect of that evidential position changing. And ground 3 is that the respondent has acted unfairly in not either informing the appellant of what the provisional view is or of the factors which would cause it to shift. My lords, the judge rejected all these arguments. He rejected the argument that the court in Abbasi had said there was a need to start from a concluded view, saying there was no such first step. That's paragraph 28 of the judgment, which is core bundle 113. He said, as my lords will have seen, that in practice what is required is that the respondent is sufficiently informed, which is akin to the standard in the House of Lords judgment in Thameside, requiring the respondent to take reasonable steps to acquaint himself with relevant information. That's judgment, paragraph 28. He also said that the respondent's refusal of the request to reach a concluded view, quote, does no more than reflect the Secretary of State's opinion, this is judgment, paragraph 29, on how best to conduct his affairs with the Nigerian authorities to give the greatest chance of providing practical assistance to Mr. Kanu, and that it's part of the conduct of international relations. He also rejected the argument that it was irrational for the respondent to maintain his provisional view, again holding that the refusal to state the view reflects the respondent's opinion on what steps should be taken best to assist him, and is part and parcel of the respondent's assessment of how to conduct foreign relations. And he says at paragraph 32 of the judgment that the distinction which the appellant has drawn between reaching a view privately and stating it publicly is artificial. That's in the judgment at paragraph 32. And finally, he has found that there is no requirement for the respondent to act fairly, stating at judgment paragraph 35 that the respondent is not exercising a power that attracts an obligation of procedural fairness. And my lords, the appellant appeals with permission against each of these conclusions. In short, it's my submission that they're inconsistent with both the law and the evidence. But before I come to those grounds of appeal, which I will take in turn, I want to address why reaching a clear or concluded view matters in this case. Why does it matter to the appellant? And the question arises because if, as the appellant accepts, the respondent may be entitled to keep any concluded or clear view he reaches private, he may be entitled to do that in the exercise of his discretion. And if, as the appellant accepts, subject to any lawfulness, he may decide, subject to acting lawfully, he may decide not to take any different steps. Why does it matter whether this private view is provisional or not? And my lords, the simple answer to that question is that reaching a clear view as to whether Mr. Kanu was the victim of an extraordinary rendition could make a difference to the steps taken. It is thus a logical first step in the decision-making process.
Write this down because I sense that it's important. Why does reaching a clear concluded view matter? Answer, because.
Because reaching a clear view as to whether Mr. Kanu was a victim of extraordinary rendition could make a difference to the steps taken. It is thus a logical first step. On the other hand, the respondent's position, which is maintaining a provisional view because he has already decided not to take the additional steps that are sought by the appellant, is back to front reasoning. It approaches the decision-making process the wrong way round. It says, what would I do? And therefore, is it necessary for me to reach a concluded view privately, as opposed to, has he been the victim of an extraordinary rendition? Yes or no? Therefore, what should I do? That is the obvious, in my submission, logical and correct way to approach the decision-making process. So what difference could it make if the Secretary of State reached a concluded view? It provides, in short, the justification for him to take a series of escalated steps to assist a British citizen detained abroad. My lord, the approach that the Secretary of State takes, the respondent takes, when a British citizen is detained abroad is set out in the Prisoner Policy Guidance, which is in the supplementary bundle. The paragraph I want to, the part I want to look at is at page 79. See, it starts at 78. And you see, first of all, a distinction that is drawn between intervention and interference. And what is said is that the UK government can intervene on behalf of a British national under certain circumstances. This is usually where we have concerns for the health, welfare, or human rights of a British national, or have concerns that they are being unlawfully or unjustifiably discriminated against. And this is what we can consider intervention. And a list of possible grounds for intervention is set out below. Health and welfare concerns, torture or mistreatment, death penalty, and so on and so forth. We cannot consider interference. intervention must be appropriate, this is at the bottom of the page, and justified. Under international law, we cannot interfere in the internal affairs of another state, including their judicial proceedings. The UK's internal affairs are similarly protected from foreign interference. And then there is a list of matters that are likely to be considered interference. Expressing an opinion, this is over the page at 80, expressing an opinion on the guilt or innocence of the accused, seeking to influence the court's judgment on a case. And other examples are given. So, my lords, there is always an imperative to avoid interference, but there is a need, nonetheless, to intervene where there are concerns. But, and you can see how this works in Miss Broughton's witness statement at paragraph 3, which is just before this in the bundle at page 54. Sorry, page 52. This is the raising of allegations with the respondent, with the Nigerian authorities. And you can also see in the way that she describes the policy at paragraphs 8 onwards, at 53, this distinction between intervention and interference, and what is happening at paragraph 14 when you send a note for bowels. We may signal, this is at page 55, we may signal to local authorities we have an interest in the case by sending a note for bail. We may ask questions, this is at paragraph 14. Often, this is from the PPG, the Prison Policy Guidance, asking questions can act as a prompt for concerns to be addressed, or the answers may act as the basis for further intervention. And she goes on to describe the purpose of how lobbying may assist. And what is clear from all of these steps is that forming a concluded view as to whether there's been a violation of international law is not essential to intervention of that type. Expression of concerns, raising allegations, or seeking assurances that a British national will receive a fair trial. These types of steps can be taken on the basis of preliminary views and on the basis of the allegations that are made. But my lords, those steps have already been taken over the last 2 years in Mr. KANU'S case. And you can see that, and Ms. Broughton has explained that the allegations, this is at paragraph 2, have been taken most seriously and repeatedly raised in formal communications. The latest letter that my learned friend asked you to read further into, again, sets out all those types of communications. But what is important is that justified intervention is not limited to those raising those kind of concerns or allegations or asking for further information. It can include more robust steps. And at this point, I would like to ask you to look at the ministerial submission of the 10th of August 2022, which is at page 141 of the bundle. Supplementary bundle, I should say. And this ministerial submission, which starts at 140, was in response to a request from those instructing me that the respondent take further steps in relation to the fact that Mr. Kanu had been the victim of extraordinary rendition, and ask for his, both acknowledging that fact and asking for his release. And you can see, if I could ask you then to read paragraphs 8 to 10 of this ministerial submission.
Yes, how far did you want us to go?
Just to the end of 10.
Right.
In the first instance, I'm going to ask you to look over the page. But so you'll see at paragraph 9 that ministers retain the discretion to depart from policy and call for release in exceptional circumstances, provided there's a rational basis for doing so. The principal exceptional circumstance where ministers have previously called for release, so it has been done, is where the FCDO has credible evidence to suggest the detainee is arbitrarily detained, although to date that has only been done in very limited circumstances. So you can see there that it is possible to call for release where there is credible evidence to suggest the detainee is arbitrarily detained. And realistically, given how exceptional that is, it's not going to happen unless there is a clear and concluded view has been taken that the individual has been the victim of an extraordinary rendition. That option remains available there. And you can see over the page why it is not recommended. What is recommended is continuing lobbying, because calling for release is exceptional. You see this in paragraph 11. Human rights violations cannot be, it needs to be done where human rights violations cannot be remedied by other means. Where we judge that call for release is a credible and effective step, we assess there are still further steps can be taken before consideration of this exceptional measure. Lobbying and escalation, you'll see, and at the end of that paragraph, monitoring ongoing legal proceedings in Kenya and Nigeria where the allegations are being considered. And you can then see at paragraph 13, the option is not recommended. We do not, to call for release, we do not assess lobbying has been exhausted, nor that all legal remedies have been exhausted, nor is it clear that a call for release would be credible or effective. The civil proceedings in Kenya and Nigeria remain ongoing. And then it says here, there will therefore be opportunities for the courts in Kenya and Nigeria to consider the allegations and potentially provide remedy to the alleged rights violations. British High Commission Abuja and Nairobi can also further escalate lobbying on the allegations to try and obtain a response from both governments. And then there is a concern that calling for release at this stage, before it's a measure of last resort, could set an unmanageable precedent. And the submission then goes on to say that it can be effective at paragraphs 14 onwards. So, my lords, calling for release in exceptional circumstances is available. And you can see from Ms. Broughton's witness statement, I won't ask you to turn it up again, but it's
Sorry to interrupt.
Yes.
Who or what is Post?
I think that's the commission in the British High Commission, as I understand it.
Thank you.
And so without turning it up again, Ms. Broughton's witness statement at page 63 of the supplementary bundle at 36A, accordingly says it's extremely rare to definitively state that treatment is illegal in international law. This is publicly. But it's rare, but it is possible. And she repeats, referring back to this same policy in the ministerial submission of paragraph 36E, this is page 64 of the supplementary bundle, is that government policy is that no representations for release of British nationals detained abroad are made other than in exceptional circumstances and usually as a matter of last resort. So, my lords, the fact that this is not merely a theoretical option, however rare, is made clear from a series of examples that are given in Ms. Shirin-Marker's second statement in the supplementary bundle at pages 145 to 151, at paragraphs 8 to 27. And you'll see that in those examples that she gives, the respondent has, on several occasions, made public statements concerning the legality of an individual's detention by a foreign government and has also called for their release. Those examples date from a series over the decades, from 1984 onwards, including in relation to the United States, rendition flights at paragraph 12, paragraph 16, the treatment of Uyghur Muslims in Xinjiang, and at paragraphs 22, the requests by then Foreign Secretary Dominic Raab, February 2021, for the immediate and permanent release of all arbitrarily detained dual British nationals in Iran, and the requests for release in Iran by then Foreign Secretary Liz Truss on the 1st of October 2021, British national Murad Tabaz, unjustly detained in Iran, paragraph 24, Nazanin Zaghari Ratcliffe, appalling decision to proceed with these baseless charges, appalling continuation of the cruel ordeal that she is going through. And there are other examples given there as well, including a paragraph 26 by the former Prime Minister Boris Johnson, acknowledging that the Indian government was arbitrarily detaining Jagtar Singh Chahal. So it can be done. But obviously and necessarily, when it is done, a conclusion is going to have to be reached that someone has been arbitrarily detained. But that is not the only difference that a concluded view could make. It could also make a difference to the decision as to whether to impose sanctions on an individual, to designate a person for sanctions. And that is dealt with in Ms. Shirin-Marker's second statement at paragraphs 28 onwards, at page 151. And she refers there to the Global Human Rights Sanctions Regulations 2020, which is in the Authorities Bundle, tab 20, at page 645. I could just briefly turn that up. And you'll see it, Regulation 4, page 646. The purposes of the regulations contained in this instrument are to deter and provide accountability for activities falling within paragraph 2. An activity falls within this paragraph if it's an activity which, if carried out by or on behalf of the state within the territory of that state, would amount to a serious violation by that state of an individual's right to life, right not to be subjected to torture or cruel, inhuman or degrading treatment or punishment, or right to be free from slavery, not to be held in servitude, or required to perform forced or compulsory labour. And just to be clear, extraordinary rendition includes within its definition arbitrary detention and transfer in the absence of lawful process for the purposes of ill treatment or interrogation under torture. So that is part of the definition, and I can give you that's what the authorities Bel Masri and Bel Haj make plain. And then at Regulation 6, the criteria for designating a person. The Secretary of State may not designate a person under Regulation 5 unless the Secretary of State has reasonable grounds to suspect that person is an involved person. And an involved person, without going through the full definition, is involved in one of these activities. Now, reasonable grounds to suspect is a relatively low test, but that doesn't mean that the Secretary of State is realistically going to impose sanctions or designate a person where he has only reached a provisional view that the activity has taken place. And if that wasn't obvious, it is made obvious by the guidance at tab 21. This is the designation guidance, tab 21 of the authorities bundle. And you'll see that the factors that the government will have regard to. The following factors are likely to be relevant, but this list is not exhaustive. This is at page 674. And you'll see paragraph 3, the seriousness of the conduct. Her Majesty's government is likely to consider the scale, impact, and nature, both of the human rights violation or abuse, and a person's involvement in that violation or abuse, including whether the conduct has a systematic nature or is part of a pattern of behaviour. So again, realistically, it is inconceivable that the Secretary of State would designate somebody for sanctions in circumstances where she hasn't even formed a concluded view herself as to whether the underlying activity that there is said to be a reasonable suspicion that they're involved in constitutes a breach of international law, such as an extraordinary rendition. So that's the position in relation to sanctions, and we can see the respondent's own approach to that in the ministerial submission of 6th of September 2021, which is in the supplementary bundle at 139. This is her approach to it in this case. And I should say that made clear that the first two ministerial submissions include, and this is the 2nd of July 2021 and September 2021, were made before the respondent had gained access to Mr. Kanu in detention. So they were made before any clear information had emerged. So this is 139. The start of the submission is at 134. And at the back, there is an annex of options. There were recommendations as to what course to take, and then there is an annex of alternative options which were not recommended. And you can see at 139 the sanctions option. If I could just ask you to read that rather than reading it out.